It's over to you.
All right. Good morning, Justices. My name is Kieran Tohill, and my colleague Preston Anderson and I will be representing the applicants in this case. The applicants are members of Ontario School Safety, a grassroots not-for-profit organization that is dedicated to advocating for safe and healthy learning environments in Ontario schools. The applicants have brought forth this case in response to the Government of Ontario's continuous failures to ensure that indoor air quality in all Ontario classrooms is at a safe and healthy level for all students within the province. In particular, it is the applicant's position that by failing to provide adequate funding, resources, and guidance to schools so as to ensure that the indoor air quality in all classrooms meets minimum standards set out by expert organizations such as the OSPE and ASHRAE, and actively revoking laws and policies that were previously implemented and enforced by the government under the Reopening Ontario Act to combat the spread of COVID, and other airborne viruses and pollutants in classrooms. The Government of Ontario has failed to fulfill their duty to protect the health and well-being of the province's students and other individuals, and in doing so has violated their rights under Section 7 and 15 of the Charter. Over the next 20 minutes, I will be outlining the applicant's arguments relating to Ontario's violation of Section 7 of the Charter before handing the floor over to my colleague who will present the applicant's arguments relating to Section 15. Now, before I dive into the particulars of the applicant's Section 7 arguments, I wanted to begin by first addressing some of the claims made in the respondent's memo that suggest this case is not justiciable because of a lack of specific legislation or state action to support the applicant's claim. In particular, throughout paragraphs 8 to 16 of the respondent's memo, the respondent seemed to suggest that the applicant's claims, particularly relating to Section 7 of the Charter, are not justiciable because, as they state in paragraph 12 of their memo in particular, they are overly broad, rely on legislation that does not bring the ministry's action upon review, and that asking this court to assess Ontario's approach to dealing with indoor air quality goes beyond the court's mandate. However, with all due respect to the respondents, their claims suggesting that this case is not justiciable appear to be somewhat misleading and ultimately incorrect based on various precedents set by Canada's courts throughout the past several decades, including some of the ones the respondents themselves cite in their memo. For one, and perhaps most significantly, many of the arguments in paragraphs 8 to 16 of the respondent's memo seem to rely on the case that they refer to as La Rose, which I believe I found under the name Luchek Guardian ad litem of in Canada, which I think is the same case because it's a case involving Andrea Luchek, who was the litigation guardian of one Cecilia Rose, and they both had the same case number. But even with that, while the quotes that from that case included in the respondent's memo are not incorrect, and the federal court did in fact find that the case's applicant's claims under the charter were not justiciable, having found that they were overly broad and non-quantifiable, and also failed to disclose a sufficient instance of state action so as to permit any charter analysis, as the respondents suggest our claims are. The respondent's memo notably fails to explain that the federal court's decision in this case was later overturned by the 2023 decision of the Federal Court of Appeal, who specifically disagreed with the lower court judge's ruling that the claims were not justiciable because the questions at issue in the case were controversial or complex, and because the legislation reflects a political choice on how to address the problem at issue, which in that case was climate change. Instead, similarly to the Ontario Court of Appeal decision in Mather, which is described in paragraph 10 of our memo, the Federal Court of Appeal ultimately ruled that by making certain legislative choices, such as enacting the Greenhouse Gas Pollution Pricing Act of 2018 and setting certain GHG emission targets for the purpose of combating climate change, the Government of Canada had made legislative choices that they said crystallized the debate at issue into law and therefore made it justiciable.
So, counsel, what about the argument that your respondents have said that the imposition on the Ministry of Education is what's inappropriate here, given that the duty is actually on principals and not on the ministry?
Yeah, so in response to that one, I would also suggest that the respondents seem to, I believe, rely on the Sigrist case, which I think they referenced in paragraph 10 of their memo. And in that, they kind of suggest that the applicants can't bring this case against the Ontario Government Ministry of Education because there's a division of responsibility between the ministry and school boards. With this case, though, I would firstly argue that it's arguably isn't binding on this court, as it's an HR Human Rights Tribunal decision that the courts themselves specifically say in the same paragraph that the respondents quote in theirs is only really applicable to cases involving the Human Rights Code of Ontario, which has no part in the current case at hand. Furthermore, in addition, that case, like the HRTO specifically states that there has to be some alleged act or omission by the province, which in this case, we're suggesting the province has taken certain steps to take responsibility upon themselves by enacting the Section 265 1J of the Education Act, and then also to some extent enacting and then repealing certain measures within the Reopening Ontario Act during the past several years. So ultimately, we would suggest that that case, if any, at best, is really should just be considered persuasive. And beyond that, it kind of provides some arguments in favor of us, as well as the tribunal seems to suggest that omissions can also be acceptable. Furthermore, in the very next paragraph, paragraph 19 of the Sigris decision, the HRTO also explains that in the BC Human Rights Tribunal case of Moore in BC, the province's liability was grounded in the ministry's funding obligations and its underfunding of the local school district, which resulted in significant cuts in services. So in doing so, the province seems to suggest, or that case seems to suggest that there are some opportunities for provinces that are in ministries of education that have a certain level of control to do so. They just have to be taking certain active steps towards it by, like, for example, making cuts to certain school districts, as is the case here. And then beyond that, as I was kind of saying with the 2023 Luchuk Federal Court of Appeal decision and the Mather decision in our memo, more recent cases from 2023 and 24 have suggested that the case law in this area might be evolving to an extent from comments that were made by Supreme Court of Canada justices like Chief Justice McLaughlin in the early 2000s, which said Section 7 cases might one day evolve to a point where they can impose positive obligations on governments to act in certain ways.
And has Section 7 evolved in that way thus far? Like, where would you rely on the court
Our
system?
main reliance with that would be the Mather and then the 2023 Luchuk LaRose case, where the two courts of appeal, the Federal Court of Appeal and Ontario Court of Appeal, overturned lower courts' decisions that said it's not justiciable for those reasons. They technically, I would acknowledge, haven't firmly admitted that, but considering we talk about our charter as being a living tree, it would argue that it is something that's open to this court to decide. So this case is undoubtedly justiciable, unlike the respondents largely suggest in some of their memo.
Council, just a
I
point
just
of
want,
question.
sorry, Maddie.
Sorry, I thought that was my echo. You go first, Liv.
I just wanted to ask, I'm going to kind of skip ahead here. So let's say that there is an obligation under the Education Act that you've now established.
Yeah.
I wanted to address whether the ministry's actions thus far, such as pledging $550 million to support clean air initiatives, including $29.5 million in their education budget, et cetera, and these other actions whether those actions meet the obligation under the Education Act, and if not, then why not, and what needs to be done?
Yeah. So going towards that, I'd say I'm just trying to find where I specifically had in our memo, but that might take a bit too much time. I know some of the secondary sources referenced in our memo, like for example, the article from the Narwhal, though discuss some of the funding things where I understand the province has made some commitments to improving ventilation in schools. However, certain people, such as, for example, the NDP's education critic, MPP Chandra Pasma, have pointed out in some like that article that the province, although they have committed, I had somewhat different numbers from that article than the respondents had, but similar enough, 1.4 billion per year to its combined school improvement and school renewal funding. The school's current repair backlog was estimated to be $16.8 billion at that time last year, which means that even if every dollar of the $1.4 billion of funding were dedicated to addressing the backlog, which it's not because it is essentially put into a fund that the school districts can put towards whatever they want within a kind of broad repair scope, it would take over a decade for that 1.4 billion to catch up to the $16.8 billion backlog. And that's assuming that there's no additional cost that any of the more than 4,000 largely aging schools in Ontario would incur during that time, which I think is highly unrealistic, like given the circumstances. Was there another question?
Yeah, Council, I'm just going to take you back to the positive social obligations here. You talk about how, the case laws may be evolving to recognize positive social obligations, but you also cite Mather, whereas I understand it, the court said that it wasn't a positive obligations case, and that it was actually sent back because there was errors in framing it as such. And I just kind of want to hear your point on whether there is a positive social obligation here, or if you're saying that it's not a positive social obligations case, and that they've sort of took on this obligation and they should meet these standards.
Um, I guess my understanding of the 2024 Mather decision, I know there's a few different ones, so I don't know if we might be looking at different ones, but was that the Ontario Court of Appeal had sent it back after the lower courts had said there was no, or there could be no positive social obligation and the case was justiciable. I think the court in the Court of Appeal case said that it's hasn't still like been formally determined if there is a positive social obligation, but that like it needed to be judged, retried by the court because the judge in the lower court had said like that there was no way there could be given that. So they again kind of left it open, was my understanding of it. I don't know if we're talking about necessarily the same one or if it might be off. But yeah. Anyways, going back to kind of our overall argument, as seen in our memo, especially paragraphs 12 to 20, it's the applicant's position that the government of Ontario has failed their duty and in doing so has violated Section 7 in several ways, including depriving the applicants and other individuals like them of their rights to life and security of the person in particular, and has done so without being in accordance with the principles of fundamental justice. Now, in particular, as you can see in starting at paragraph 12 of our memo, reports by organizations like Ontario School Safety, the one provided for this class, and the
Council, I'm going to have to ask you to wrap up in about 15 to 20 seconds. That's okay.
Rely on clear scientific medical evidence that shows how prolonged exposure to poor indoor air quality is harmful to children's health and well-being in the long term. Given that and the wide body of case law supporting how this can constitute a violation of individuals' rights under Section 7 of the Charter, and how it could even at worst lead to serious harm, threats to individuals' life by worsening respiratory conditions such as asthma and CPCE, we argue that they have clearly done so. And in doing so, it's not justifiable because this is a grossly disproportionate law where they've although in the Education Act, they claim to be seeking to protect children and students' health and well-being, they're taking actions that don't do so by failing to ensure that funding or steps are taken by schools to protect the indoor air quality, and by repealing actions like the Reopening COVID Act or Reopening School Ontario Act post-COVID, which had previously done a better job of protecting. Moreover, as we know, some of the co-applicants, such as SH, have attempted to donate HEPA filters and masks and taken other measures themselves, but have been unable to do so because of various policies and the government not doing a good enough job. As a result, we argue ultimately that the Ontario has clearly violated Section 7 and that it can't be justified under Section 1, which I would also want to note that the respondents didn't seem to make any arguments in relation to in their own memo, perhaps because Section 7 violations usually are very difficult to justify under Section 1. But beyond that, because I think this is a case where they're not really serving any pressing substantial objectives or rationally connecting it, and the effects on the applicants are not minimally impairing. Thank you, Justice. I'll now hand it over to my colleague who will discuss Section 15.
Thank you, Kieran. Honorable Justices, we stand before you here today to address a critical issue of inadequate indoor air quality in Ontario public schools, a matter that directly threatens the health and safety of children who attend them. The applicant, members of the Ontario School Safety, a grassroots group committed to improving in-air quality in schools, bring this case forward not only to protect the well-being of their children, but to assert their constitutional rights under the Canadian Charter of Rights and Freedoms. This challenge is a call for Ontario to fulfill its duty to ensure a safe and healthy learning environment for all students, particularly those with underlying health conditions like asthma or compromised immune systems. My co-counsel has already discussed the Section 7 concerns. I will begin by addressing some concerns raised by our friends, and then I will move into a Section 15 analysis on the equality rights impacting BH. Firstly, our friends will argue that there is no Section 15 violation. Ontario claims that there's no law or state action infringing BH's Section 15 rights, as there is no positive obligation to ensure air quality standards. However, this argument overlooks the fact that Section 15 not only protects individuals from laws that explicitly discriminate, but also from laws, policies, and omissions that create adverse impacts, especially when those adversely impact are vulnerable or enumerated groups. In this case, poor air quality disproportionately harms students like BH with asthma and students with immunocompromised family members. The failure to provide adequate measures to protect these students, particularly given the known health risks of poor in-air quality, can be seen as systematic discrimination. The lack of air quality.
Oh, sorry. Very quickly, sorry to cut you off. I wanted to ask a question about the basis of your claim. In your memo, I didn't see any establishment that the charter applies to the school board and the defendant, because you didn't establish that they were government under the charter. Is there a reason for this? And do you believe that they are government for the purposes of the charter application?
Thank you, Justice. It is the applicant's position that they are government under the charter, and it was a mere omission that it was not mentioned in the memo. This is established similarly when looking at other case law, which has seen schools when operating in the capacity of providing education as being regulated by the charter. However, they would not be regulated under the charter if, for instance, it was a labor dispute issue. Our friends will also argue that there's no discrimination based on a physical disability. Ontario contests that asthma and immunocompromised status should be treated as analogous to physical disabilities should not be treated as analogous to physical disabilities like blindness. However, this overlooks legal precedent, particularly in Eldridge, where the Supreme Court acknowledged that discrimination can occur when a disability impacts a person's ability to access services. Asthma, like blindness, is a medical condition that can impede an individual's ability to safely participate in daily activities, including attending school. The failure to provide adequate air quality protections for children with asthma or for those who live with immunocompromised individuals perpetuates disadvantage and can be seen as a failure to accommodate a recognized disability under Section 15 of the Charter.
Counsel, sorry for interrupting, you mentioned Eldridge. With the Section 15, I can appreciate how individuals that do have these pre-existing health conditions would be disproportionately impacted by this. I think where I'm struggling with your comparison to Eldridge is that the case law there is that when a government does take on a positive social obligation, it is to do so in a non-discriminatory manner. So I guess I'm going back to my first question. I'm just struggling here. Are you saying that the government did take on this obligation or the school board did take on this obligation, and so it is obliged to do so to meet the conditions of these individuals that do have pre-existing health conditions?
The position of the applicants is that providing education and schooling is a positive social obligation. And in taking on this role, the Department of Education should take it on in a manner that does not discriminate against individuals based on a disability. Just as it would be unacceptable for a school not to be accessible by people with a physical disability like double amputees, it also should not be permitted that a school is not accessible to somebody simply because they have asthma or simply because they are blind or simply because their family members are immunocompromised.
But are you sure that schools aren't already doing that? Are we positive that schools are providing access for people that may be disabled? Like there are many schools that are in your own submissions that you talk about the kind of deficit in spending to bring up infrastructure. So is that not a default that this is partly what's accepted, that it's not possible to accommodate all individuals?
Justice, that's an excellent point, and perhaps it is accepted. However, it ought not to be. In cases like this, we have a positive social institution, education, which should be accessible to all students, which is not being made accessible. Budget deficits are definitely a consideration. However, the Ontario government has put aside money to improve in air quality. However, it has not done so yet, and is not doing it to a sufficient standard to allow students like BH to obtain the same educational situation as other non-disabled students. And that's simply not acceptable under the Charter.
Thank you.
Council, I wanted to ask, I know in Section 15 cases, reinforcing, perpetuating, and exacerbating disadvantage is very crucial and important, and the fact that there is a pre-existing disadvantage that is being affected. So I wanted to ask about the disadvantage that is currently placed against people with asthma or who are immunocompromised. So how can that be compared to the disadvantage that people with disabilities perhaps face, as mentioned in Eldridge? Like, how can that be compared to someone who is blind, the disadvantage that they face in society?
Excellent question, Justice. While the disadvantage is inherently different, the disadvantage exists nonetheless. While an individual who's blind may be at a greater disadvantage in more circumstances, that doesn't disregard the fact that individuals with asthma cannot participate in a variety of activities. It's a lot harder to play sports with asthma. It's a lot harder to go into places that don't have great air filtration. These individuals are at an existing disadvantage, and this disadvantage is being perpetuated by the school system by not providing increased air quality. Just in the same way that an individual who's blind may not be able to guide themselves around the school, an individual with asthma may not be able to participate in a school setting because of the impact on their lungs, because of the potential longer lasting impacts of the poor air quality. Finally, our friends will argue that budget constraints should factor into this consideration. However, Ontario suggests that the Ministry of Education's time and resources are better spent on tackling the issue than defending itself in court. However, this defense undermines its applicant's fundamental argument that the ministry's failure to take a swift and concrete action on indoor air quality is an ongoing violation of students' rights. Rather than dismissing the issue as a difficult challenge, the government should prioritize the health and safety of vulnerable students, especially those with known medical conditions, over less other urgent concerns. Continuing to defer action only exacerbates the harm caused by poor air quality. I will now move into my submissions on Section 15. Section 15 guarantees equality before the law and equal protection of the law, particularly without discrimination based on physical or mental disability. The applicants submit that Ontario's failure to address indoor air quality in schools is a violation of this provision, particularly in the case of BH, who suffers from asthma. The Supreme Court in Fraser established that discrimination occurs not only when a law explicitly targets a disadvantaged group, but also when a state's action has an inverse impact on individuals in that group. In this case, the lack of an appropriate in-air quality measure in school disproportionately harms children like BH, who have chronic respiratory conditions, and create an adverse impact on them compared to their peers. This distinction is not justifiable.
Council, very quickly, do you believe, oh, sorry, you're someone has to not be muted.
Yeah.
You put the proposition that Section 15 is violated when there is omission from the government, but clearly the government can't accommodate everyone all at once at the same time for everything under the sun. Do you, in making this claim, have a floodgates fear that there will therefore be no plaintiff and no person who in some way isn't accommodated towards, and there would be trickle-down economic and funding concerns that would then spread the government too thin to actually properly accommodate anyone? Surely the immunocompromised can't attend school in any capacity because they will always have some risk of being sick. There will always be some risk. How will clean air in this scenario, one, not create a trickle-down economic effect, but two, solve the problem that you're putting forward that your plaintiff has at the moment?
Excellent question, Justice. The applicant's position is that a floodgate concern is typically not enough to protect a government from being required to take action. This is supported in Jane Doe versus Toronto Metropolitan Police, where the Supreme Court argued that a floodgate concern is not sufficient to prevent a requirement for the government to take action and typically cannot provide the sole basis for protection against the government being required to take an action. And the applicant's position is that the potential risk of a floodgate does not remove a government obligation to provide equal access to all students. Justices, I see my time is up. Could I have 30 seconds to quickly conclude?
Yes, you may.
In conclusion, the applicants respectfully submit that the Ontario government has failed in its constitutional duty to provide a safe and healthy learning environment for children by disregarding the clear evidence of harm caused by poor in-air quality and failing to provide the necessary accommodations. Ontario has violated the rights of children with respiratory conditions under Section 7 and 15 of the Charter of Rights and Freedoms. The applicants urge that the court hold Ontario's inaction as unconstitutional and that the government must take immediate steps to remedy this failure by providing adequate in-air quality standards and accommodations for all students in Ontario schools. Thank you.
Thank you, counsel. I now turn to the respondents.
Good morning, Justices. My name is Bernardo Calazans, and I represent the defendants in this application, along with my co-counsel, Alex Mangiardi. At its core, this application attempts to answer a fundamental question regarding the applicability of constitutional adjudication to claims about inadequate state action. Our arguments will be structured as follows. I will argue that the Section 7 claim put forth by the applicants is not justiciable. On the other hand, my co-counsel will argue that Section 15 is not violated since no legislation grounds the alleged violation. Instead of addressing the claims made by the applicants in their submissions, I will just move into my submissions because it will clear up a lot of the confusion that has generated within the applicant's remarks about Section 7. It's useful to spend some time delineating the scope of justiciability. In the 1989 Supreme Court decision of Canada Auditor General v. Canada Minister of Energy, Mines and Resources, the court held that justiciability is, quote, first and foremost, a normative inquiry into the appropriateness as a matter of constitutional judicial policy of the courts deciding a given issue, or instead to defer to other decision-making institutions of the polity. To simplify it, it is whether the court has institutional capacity and legitimacy to adjudicate the matter. Justiciability is concerned with the court's proper role within Canada's constitutional framework and the time-honored demarcation of powers between the courts and the other branches of government. Although there's no set rule that determines the scope of justiciability, the approach must be contextual, which is why the Federal Court of Appeals decision in LaRose found the claims to be justiciable, but nonetheless sent the claims back because they were too broad and diffuse to be adjudicated effectively. In paragraph 3 of the applicant's factum, the applicants allege that Ontario has failed to provide the necessary resources contrary to Section 265(1)(j) of the Education Act. However, a close reading of this provision says very little about the obligation that is thrusted upon the Ministry of Education. What it does say, however, it is that it's a duty of a school principal to give assiduous attention to the health and comfort of the students. This provision does not impose an obligation upon the Ministry of Education to maximize or improve indoor air quality. In Sigrist, which is a 2008 decision of the Human Rights Tribunal, it was maintained that the fact that school boards are creatures of provincial legislation cannot render the province responsible for each and every action of every school board's decision, let alone of every principal.
So the council, the idea of assiduous attention, in the legislative kind of interpretation would suggest that this is something that is more than just a passing observation. The language of assiduous would suggest something very methodological, persistent, consistent kind of attention. So doesn't that change this from being each and every action of the school board to specifically legislative requirements of a school board?
Certainly, Justice. It does enhance the attention that ought to be given, however, not by the Ministry of Education. Had the legislative power intended to bring the Ministry of Education liable under Section 265, you would have said so, you would have made it clear. Instead, what he does is simply specifies that it is a duty of a principal to pay attention and to give assiduous attention to the health and comfort of its students. Indeed, the decision of Sigrist, it is a Human Rights Tribunal decision. However, if we take that position to its very core, in a hypothetical situation, the assumption that the failure of a principal under Section 265 of the Act would render the Ministry of Education liable is a difficult one to comprehend. Essentially, the Ministry of Education would be perpetually embroiled in litigation due to the failure of a principal to adhere to one of the enumerated duties under Section 265. This cannot possibly be what the legislative power would have wanted, since it leads to an absurd result and an absurd interpretation of the Act. Thus, reliance on this provision is misguided.
Counsel, I want to interrupt you there. So I can appreciate how you're saying that the Section 7 charter rights don't apply here. If it comes down to the principal, could you say that they have breached their duty of care to BH in these circumstances, and that it would be better decided as a private law case as opposed to public because that duty has been breached?
Thank you, Justice. As it pertains to constitutional adjudication, which is what this is about, a necessary breach in duty of care would not necessarily factor into a Section 7 analysis. Had the applicants wanted to bring this case, as you said, in a private law manner, they would have done so. But the fact of the matter is they're suing the Ontario government for an alleged failure to do something when the government itself has taken notice about the issue and has acted upon the very issue that the applicants claim they have not.
Counsel, how would you respond to an argument that Ontario imposed an obligation upon itself through the Reopening Ontario Act as opposed to through the Education Act?
Thank you. This is one of the very claims that rendered the LaRose decision non-justiciable. And if you want to take counsel's characterization of the Federal Court of Appeals decision, it sent back the claim because it was too broad and diffuse. Similarly, we cannot simply just pick whatever piece of legislation we decide to do and then attach that and characterize that piece of legislation as a failure on the part of the government to assert a failure on the government to do something. As it pertains to the Reopening Act, any sort of action on the part of the government could lend itself to be manipulated into seeming like a liability on the failure of the government. I'm not sure if that answers your question, Justice, but
Thank you, Justice.
It's part of the diffused and broad claim nature of picking whatever act you decide to frame your claim upon and then claiming that it's a failure of the government, specifically as it pertains to a Section 7 analysis. What is left after
Counsel?
Yes.
Can you address me when duty of care is breached? What become the appropriate measure that should be taken to remedy it?
So Silas, we're probably gonna not take questions from beyond the judges just for now, so we can ask that afterwards. So just because of the restrictions and time.
All right.
Yeah.
What is left after, therefore, is a broad and diffuse claim about the failures of the Ontario government to answer Justice Olivia's question, which is precisely what the plaintiffs in LaRose claim. In that case, it was argued that the federal government's conduct concerning CO2 emissions constituted a constitutional violation of their life, liberty, and security of the person under Section 7. However, the plaintiffs did not ground their claim under a specific piece of legislation, which led the federal court to render the claim non-justiciable. Thus, we submit the Section 7 claim is not justiciable for the same purposes as it was found in LaRose. Nonetheless, I will still proceed under the assumption that the claim is justiciable. Section 7 of the Charter is infringed if legislation or state action interferes with or deprive a plaintiff of their life, liberty, or security of the person, and if such interference is not in accordance with principles of fundamental justice. Premise under this analysis, however, is a challenge to a particular law or its application. However, as mentioned previously, relying on the Education Act provision is misguided as it pertains to a Section 7 claim. Thus, the analysis must be conducted through the perspective of what the Ontario Court of Appeal in Tanujada calls a network of state actions. Paragraph 10 of the applicant's factum, this state that Section 7 of the Charter can be violated by government inaction that creates foreseeable harm. However, with respect, the very notion of foreseeability is nowhere to be found in any of the cases that the applicant cites. Cases like Gosselin and New Brunswick, VGJ, that are both cited in the applicant's factum as support for this proposition. Each one of these cases is distinguishable from the case at bar, since each one of these cases had a underlying piece of legislation that backed the alleged state inaction. In the interest of time, I will move on to state that Certainly, there's no question that BH's security of the person is infringed in this instance. Although we understand that financial and budgetary constraints should not be used as a complete defense to a Section 7 claim, they do nonetheless come into account when deciding whether an action is grossly disproportional or arbitrary. As stated, Ontario has taken notice. It has invested over $550 million to support air quality in schools. It has assessed or recommissioned 99% of the mechanical ventilation systems, and the ministry has allocated nearly $30 million to improve school ventilation. Such actions cannot be deemed to be grossly disproportionate nor arbitrary to the stated purpose of protecting the health of students. As it pertains to the claims about air filters, donation of air filters in schools, it is similarly non-arbitrary because it's difficult to know how long these filters have been sitting around or even if they're functional. Allowing these filters to be donated could have detrimental effects since there's a possibility that it could actually worsen the air quality instead of doing what they were supposed to do in the first place. Make sure that these are viable.
Council, when you say that there's a possibility that donated air filters could worsen the quality of air in the schools, can you expand on that more? It seems to me that even if a student or a parent has a concern and donates even a poor air quality filter, a portable filter, some improvement would be better than nothing. And that it's very rare or unlikely that someone's donating a filter that actually worsens the air quality in schools. Do you have any basis for this claim?
So for every filter that might improve air quality, there might be a filter that isn't working, Justice, which renders the refusal to have a filter donated to the school not arbitrary to the stated purpose of protecting students' health. To ensure that these are viable, the Ontario government would have to spend a significant amount of its already constrained budget to make sure that these are viable for use. If I can ask 30 more seconds to have my submissions.
Yes, yep, no problem.
Just as individuals like BH should be afforded the most amount of protection the state has to offer. However, Ontario has an immense burden to deal with when it comes to its budgetary constraints. It is not the responsibility of the government to maximize life, liberty, or security of the person. The very function of the charter is to prevent the government from infringing upon a constitutional guarantee. I've attempted to demonstrate the Section 7 claims put forth by the applicants is not justiciable since it lacks a specific piece of legislation to ground it. But should the court find the opposite, the claims are justiciable, we submit that the infringement on the life and security of the person in interest is made in accordance with the principles of fundamental justice. If the court does not require my assistance any further, I will call on my co-counsel, Alex Mangiardi, to explain why there is no violation of Section 15 of the Charter.
Thank you, counsel.
Hello, esteemed judges and guests. My name is Alex Mangiardi for the respondent, the Ontario Ministry of Education. So I'll be presenting the final issue in our claim, which is that there is no violation of Section 15 of the Charter. Now, similar to what my co-counsel has said regarding Section 7 of the Charter and any possible violations, Ontario also believes that there is the issue of judiciability. There is no law nor policy in place that is infringing on the rights of BH. Thus, if there is no law nor policy, this matter is beyond the scope of the Supreme Court of Canada. The Supreme Court of Canada cannot mandate Ontario to stop doing something that it is not doing, or to begin an action where there is no positive legal obligation. Now, throughout the factum, the applicants attempt to advance several claims without evidence. Firstly, they compare BH's asthma and immunocompromised state of BH's grandmother to blindness. This is done without any evidence as to the severity of such diseases to be considered the level of physical disability in Ontario, nor have they shown the legislative intent from the province to consider these conditions as part of the physical disability umbrella. Secondly, the applicants claim that BH's school is unsafe. They provide no evidence for this claim, nor do they provide any criteria they are using to consider schools safe or unsafe in their memo. Referencing paragraph 26 of the respondent memo, SH is comfortable with hiring a French tutor for BH. Thus, SH understands that many different activities can be done outdoors to help BH not only academically, but also to continue to develop the relationship that BH has with their peers. The province does not feel that it is fair to ascribe a possible breakdown in the relationship this child has with their peers to the ministry, while the ministry is not keeping BH from attending school, but rather SH is continuing to prevent BH from attending school. They also have not shown any alternative routes to maintaining the child's connection to peers. Similarly, in paragraph 27 of the applicants, they continue to put forth claims and theories with no evidence nor legal tests for causation provided. Instead, they claim that Ontario is responsible for the economic hardships that they are currently experiencing. There is no guarantee that the Charter will maximize a person's economic condition, nor does current economic hardship affect the Charter analysis and adjudication. Furthermore, the applicant is not being deprived, of income by the state directly. Parenting requires many sacrifices, but Ontario cannot see the connection between the economic sacrifices a parent makes and the original claim that BH's Section 15 rights were being violated by a policy put forth by the government. The applicant brought forth this claim. They have not shown the many different routes that they took to ultimately take this current course of action, which is to hold or withhold BH from attending school. Instead, it appears. Yes.
Question for you. But if the argument, as I understand it, is that there's an expectation, given the legislative requirements for the proper ventilation in schools, and that failure to meet that expectation is what's deprived this mother here of the right to freely send her child to school without risking that child's life, liberty, security, or person. So how would you respond to that?
Well, that's a great question, and I think they'll be continue to be answered later on in our submissions. But to give you a brief preview, we're going to be speaking about how Ontario has put forward a lot of both financial commitments and also legislative commitments, such as Bill 140, the Improving Air Quality for Our Children Act, which is to help kind of relieve this problem that exists of air quality in schools. But of course, there is, the reality that we face as citizens of this government, which is unfortunately big governmental tasks take time. They take time, they take money, and these things cannot be solved overnight. So, frankly, Ontario cannot be held. We just feel that, to bring forth a case in which the Supreme Court of Canada has to tell Ontario, hey, spend your energy here adjudicating this case about how slow or not slow you are working towards this measure. We'll continue speaking about that in our submissions, but that's going to be our position going forward. So, like I said, right, Ontario has introduced Bill 140, the Improving Air Quality for Our Children Act. As one of the justices said earlier, this bill, on top of the many financial commitments that were put forward in the research report, such as $550 million, demonstrates an ongoing policy commitment from Ontario to promote this initiative and finance it appropriately. Now, it remains to be seen which policy the applicant was referring to throughout their factum, and specifically in paragraph 41 of the applicant memo, where they allege that, quote, Ontario policy decision to not provide clean air filters. Now, of course, this was brought forward without any evidence, and in Bill 140, with all the financial commitments that are there are certainly monies allocated to provide clean air filters. Now, the continued allegation that such a policy exists, again, lacks evidence and does not fully illustrate what is really going on in Ontario schools. Now, there is a significant commitment to providing clean air filters to schools, and any failings of this goal should be properly ascribed to budget shortcomings and the length of time it takes to solve such complex problems. Additionally, in paragraph 46 of the applicant memo, the applicant seems to agree with us, the province, that this is a very difficult problem to solve and that it would cost a lot of money to tackle said problem. However, further in this paragraph, there is an insinuation that there exists the money to solve this issue, but it is just not allocated properly to the Ministry of Education's budget. Therefore, we, the respondent, are disappointed as to why the applicant continues to push the narrative that there is an Ontario policy that undercuts the initiative that the ministry itself has helped to support. Now, in paragraph 34 of the respondent memo, we highlight that the applicant continues to make the repeated false claim that there has been, again, another quote, a decision not to provide clean air filters taken by the ministry. No such policy or decision exists, nor has evidence regarding this has been presented. BH's school does not accept donation of air filters. Now, this is a far cry from what's alleged. There are many reasons as to why BH's school does not accept, and one of which is that they are complying with the current Ontario initiative and being provided with adequate filters. As my co-counsel said, there are a myriad of reasons why a school may or may not accept donations of filters, and probably the most streamlined and effective way is just to continue complying with the Ontario initiative and receiving the adequate filters that are compatible with the HVAC system, and the government will be providing the schools.
Counsel, if I can interrupt you for a second, just taking you back to your Section 15 analysis, just for a point of clarification, are you stating that because it's your submission that asthma doesn't account to a disability and thus the Section 15 analysis does not apply here?
No. But in the alternative, if asthma did qualify as a physical disability, there is still so much material that that shows that one, there is not this kind of cabal of people on the Ontario government making a position that undercuts the initiative, or that there is a policy to undercut Bill 140. So if asthma does reach a physical disability, there would still not be a Section 15 violation. If asthma does not reach that level, well, again, there's still no policy nor positive state action that is oppressing BH's Section 15 rights.
Sorry, just to add on to that. So I think we can take some judicial notice, though, to say that people who do have respiratory illnesses would be disproportionately impacted by inadequate indoor air quality, and that might perpetuate the activities that they aren't able to participate in because of that underlying illness. I'm just wondering if you could help me out here how this doesn't meet a Section 15 claim.
Of course. And it is a good question because, frankly, the claim that the applicants are putting forward is that Ontario is going too slow, or we're not committing too much resources to this, even though Ontario has shown a direct legislative and financial commitment to solve this complex issue. So again, is Bill 140 the state action that is oppressing the Section 15 rights of BH? No, because it's actually a bill to help alleviate that concern that SH, the parent of BH, has in improving the air quality of said school in order for BH to return in person and have, to continue their successful education. Now, if I could just ask for a brief little indulgence to finish our point here.
Yes, no problem.
Thank you. So again, we've spoken about budgets. So frankly, Ontario feels that this claim has really kind of gone off the rails a little bit, right? So again, we are a little concerned how kind of budget shortfalls that cannot be ascribed to the ministry are connected to a Section 15 claim. But again, this is due to the broad scope of the applicant's memo, and also for this reason and many more shown by my co-counsel that frankly this claim has no basis. But as stated in the research reports, Ontario is working on rectifying this problem. And if the ministry goals are hampered by the amount of money they receive from the provincial government, that is something that the ministry unfortunately has no control over. The ministry's time and energy can be better spent on carrying out the initiative set forward by Bill 140 and the financial commitments thereof. And instead, we should focus on kind of continuing the forward momentum and the inertia that Ontario has to complete this problem. So with that said, that concludes the submissions for my co-counsel on Section 7, myself on Section 15. And with that, our order sought being that this claim is properly dismissed. So without any further
Counsel, there is an opportunity, should there be desire, for either Kieran or Preston to take a few minutes to have a rebuttal. Of course, it's not necessary. Would you like to exercise that option, Counsel?
Yeah, I'll address just a couple of things, if I can.
Yep.
Just start now?
Yeah, this would be a little stricter time. We have to make sure.
Okay, yeah. So just a couple things I wanted to address from some of the things the respondent said, to avoid kind of repeating a lot of what I had pointed out about the Sigrist and, as the opposing counsel calls it, LaRose decisions. These are ones that we feel like aren't really relevant to the case, because the LaRose one was ultimately overturned in the 2023 decision. And the Sigrist one is an HRTO decision, which also we argue kind of goes towards it. More specifically, though, the respondents also made a point that some of the cases referenced in our memo are distinguishable and did not contain foreseeable harm. I mostly just wanted to emphasize that although the case at hand is dealing with an issue that is distinguishable from the cases we reference in it, because unlike climate change or the Quebec's healthcare policies, our arguments still are following the Section 7 analysis that was outlined in recent landmark Supreme Court decisions dealing with Section 7, like Bedford and Carter. And although different in their facts and circumstances, I would argue that they could actually be seen to involve a more foreseeable risk than the ones seen in more recent climate change decisions that I had talked about, such as Mather in the 2023 Luchuk decision, as the harms that are known to come from prolonged exposure to poor indoor air quality, especially on people like BH or a grandmother who, because of their age and or certain health conditions, are more likely, is more specific and foreseeable than the claims in those climate change cases, which were requesting a new right to a healthy and livable environment. As a separate one, opposing counsel also just said it a few times that number one, the BH's school was not accepting air filters because they already had filters in schools under Ontario's policy. I don't know where those facts came from, as there was nothing about that in the fact pattern or anything, but there is substantial evidence that many schools do have classrooms with insufficient air quality levels, and that the province doesn't do a good job in general of monitoring it in the first place to ensure that they do, and so on. Finally, they also argued that not allowing individuals to donate air filters is not arbitrary, because some of the air filters could be broken, which would then render them arbitrary in their purpose of improving indoor air quality, as I understood it. Finally, but I wanted to take issue with this a bit, just because I feel like I don't really understand how it would be problematic for parents to be donating these air filters in that position. The fact pattern didn't necessarily make it explicitly clear why SH wasn't able to, but ultimately there should be no issues with them doing it for any health reasons, because at worst, even if the air filters did break, as the opposing counsel suggested, those filters would still have been there on the parents' own wish, which would have allowed them to exercise their rights more effectively.
Thank you, counsel. Would the respondents like to exercise their right for a few extra minutes?
I'll actually just go forward and say yes, only because well, I thought these responses were for issues of law, not issues of facts, but I'll reply just to what our friends across the way have said. Again, with regards to the air filter, this was just one of the many hypothetical possibilities as to why certain things were, why a school should or should not accept donations and why they had that policy in place. Again, it's just one of the many kind of hypotheticals we're putting forward, just as the applicants are putting hypotheticals forward in their memo as well to defend their positions. So
great. Thank you. Well, that was a great job, folks. We're going to take a 5-minute break and then start the next one. So everyone wants to take a couple minutes. It's never easy to go first. And Preston, thank you for participating and helping us have a full slate. We really appreciate that. And great job for our first group. And we'll be back in 5 minutes to start the next one.